You just buried your mother. While you're still sorting through the folded funeral programs on your nightstand, you get a phone call. The voice on the other end is aggressive. They claim your mother owed $42,000 on a credit card, and they want you to pay it immediately. The caller knows exactly what they are doing. They use your grief against you, pressing hard on your sense of moral obligation to clear her name. They insist time is running out, manufacturing a crisis to force you into making a panicked decision. But this is a civil dispute, not a criminal one. Under the law, a debt collector has absolutely no power to arrest you, detain you, or send the police to your door. The worst they can do is file a lawsuit. That intense pressure you feel on the phone is a carefully constructed illusion. Unless a few very specific legal exceptions apply, stepping up to pay your parents' unsecured debt is entirely voluntary. The threat that you are personally on the hook is a lie. The person calling you likely doesn't even work for the credit card company. They are a third-party debt buyer. These agencies sweep up massive portfolios of dead accounts, debts owed by people who have passed away with no money left to pay them. This chart shows how their business model actually works. They buy that $42,000 debt for fractions of a cent on the dollar. If their intimidation tactics convince even one grieving relative to pay up, they turn a massive profit on the entire portfolio. They target families in mourning on purpose. They are betting that you don't know the strict legal boundary that separates your personal finances from your deceased parents' past obligations. The moment you learn exactly where that strict legal boundary is drawn, the debt collector's psychological leverage completely evaporates. When a person dies, the law immediately creates a temporary financial ghost called the estate. This legal entity steps in and absorbs everything your parent left behind, every house, every car, and every credit card balance. During a legal process known as probate, the estate is forced to settle up. It uses whatever assets remain in the estate to pay down those balances, canceling out the debts using only your parents' money. If the estate runs out of money before the bills are paid, it becomes insolvent. At that point, the remaining unsecured debt legally dies with the estate. It cannot cross over to attach to the living children. The estate operates as an impenetrable legal firewall. It sits permanently between your deceased parents' creditors and your own personal bank account, blocking them from ever reaching your money. That firewall works perfectly, unless the collector can find a legal bridge around it. There are 4 specific exceptions that can pierce the estate's protection and connect you directly to the debt. The first major exception is cosigned debt. If you legally agreed to share the burden when the account was originally opened, that debt survives your parents' death, and you remain fully responsible for the balance. This map shows the second exception, community property states. If your parent lived in one of the states highlighted here, like California or Texas, a surviving spouse might still be legally on the hook for debts acquired during the marriage. Children, however, remain protected. The third exception involves filial responsibility laws. These are obscure state laws, most actively enforced in Pennsylvania, that can legally force an adult child to pay for their parents' unpaid medical or nursing home bills. This is a highly dangerous loophole because it catches heirs completely off guard. You don't have to co-sign anything to be hit with a crippling medical bill. The state law simply imposes the liability on you by default. The fourth legal exception is attached assets. If you inherit a house or a car that still has a mortgage or a lien on it, the bank retains a legal claim to that specific property. Even though you don't personally owe the money, the bank can repossess the asset if the payments stop. Memorizing these 4 specific exceptions is your best defense. If your situation doesn't fit neatly into one of these categories, the collector's demand is nothing more than a predatory bluff. Let's go back to that ringing phone on the nightstand. You aren't a panicked victim anymore. You are an educated consumer, and you know exactly where the legal boundary is drawn. Now you can pick up the phone and invoke the Fair Debt Collection Practices Act. The FDCPA is a powerful federal law designed specifically to shield you from abusive, deceptive, and harassing debt collection tactics. This is the Federal Trade Commission in Washington. They actively enforce the FDCPA, routinely tracking down and shutting down predatory debt collection rings that violate these exact rules. Simply telling the caller that you know your rights under the FDCPA flips the script immediately. It signals to the agency that you are a hard target, and their intimidation tactics will fail. From there, follow the golden rule of handling ghost debt. Never agree to pay a single cent, and absolutely refuse to accept any manufactured guilt over the phone. Instead, give them a simple set of instructions. Tell them to contact the estate's executor and demand that they send a formal proof of claim in writing. The vast majority of these scavengers rely purely on fear. Once you force them to provide written, legal proof that you actually owe the money, proof they know they do not possess, they will immediately abandon the pursuit and move on. Paying a bill you don't owe doesn't clear your parents' name. Honoring their legacy means protecting your family's financial future, rather than subsidizing a debt scavenger's bottom line.